Okay, let's begin with question and answer session Q&A. Acceptance of deposits. Companies Act 2013. Multiple choice questions. The first question is regarding Varsha Limited decides to raise deposits of 20 lakhs from its members. However, it proposes to secure such deposits partially by offering a security worth 15 lakhs. It was partially securing. Which of the following option is best to describe such deposits? So it was partially or no securitization was made. So in this case, we can consider that is the option is unsecured deposits. ఒకవేళ ఫుల్లీ ఛార్జ్ క్రియేట్ చేసి ఉంటే దానికి మనం ఆప్షన్ ఫుల్లీ సెక్యూర్ డిపాజిట్స్ వచ్చి ఉండేది. బట్ హియర్ పార్ట్కి ఒక సమ్ పార్ట్కి మాత్రమే ఛార్జ్ క్రియేట్ చేశారు కాబట్టి unsecured deposits is the answer. What is the maximum tenure for which a company can accept or renew deposits from its members as well as from public? Minimum tenure వచ్చి 6 months, maximum వచ్చి 36 months. మ్యాక్సిమం ఒక డిపాజిట్ యాక్సెప్ట్ చేసిన తర్వాత ఒక డిపాజిట్స్ని పబ్లిక్ దగ్గర నుంచి ఆర్ మెంబర్స్ దగ్గర నుంచి రిసీవ్ చేసుకుంటున్నప్పుడు మ్యాక్సిమం 36 monthsకి మాత్రమే టెన్యూర్ పెట్టుకోవాలి. దట్ ఈస్ యాజ్ పర్ ద కంపెనీస్ యాక్ట్ రూల్స్. నెక్స్ట్ థర్డ్ క్వశ్చన్, ఫిన్ లిమిటెడ్ ఈజ్ యాక్సెప్టింగ్ deposits of various tenure from its members. From time to time, the current register of deposits maintained at its registered office is complete. State the minimum period for which it should mandatorily preserve that records. So minimum 8 years. Minimum 8 years from the financial year in which the latest entry is made in the registrar. Next, every company shall pay a penal rate of interest of 18% per annum for the overdue period in case of deposits, whether secured or unsecured, matured or claimed but remaining unpaid. ఏదైనా డిఫాల్ట్ చేసి ఉంటే పీనల్ రేట్ ఆఫ్ ఇంట్రెస్ట్ వచ్చి 18% కంపెనీ పే చేయాల్సి ఉంటుంది డిపాజిటర్స్కి. యాజ్ పర్ ద ప్రొవిజన్స్ ఆఫ్ కంపెనీస్ యాక్ట్ 2013 and relevant rules thereunder, an eligible company is not permitted to accept from public or renew the same deposits, whether secured or unsecured, which is repayable on demand or in less than 6 months. Further, the maximum period of acceptance of deposits cannot exceed 36 months. But for the purpose of meeting any of its short-term requirements of funds, a company may accept or renew the deposits for the repayment of earlier than the 6 months, subject to certain conditions. Next, descriptive type of questions. First question is regarding enumerate the amounts which, when received by a company in the ordinary course of business, are not be considered as deposits. In the ordinary course of business are not to be considered as deposits. Circumstances where the ordinary course of business, the amounts are received in the ordinary course of business also, it could be not considered as deposits. Okay. డ్యూరింగ్ ద కోర్స్ ఆఫ్ బిజినెస్లో రిసీవ్ చేసుకున్నప్పటికీ వీటిని మనం డిపాజిట్గా కన్సిడర్ చేయము. అంటే ఆపరేషన్స్, సేలింగ్ ఆఫ్ గూడ్స్, ప్రొవిజన్ ఆఫ్ సర్వీసెస్ ఆర్ ఎనీ కాంట్రాక్ట్ ఆర్ ఎనీ మూవబుల్ ప్రాపర్టీ పర్చేస్ చేసినప్పుడు కావచ్చు, ఎనీ ఫ్యూచర్ ఫోర్సిబుల్ కాంట్రాక్ట్స్, ఫారిన్ కాంట్రాక్ట్స్, ఎక్స్చేంజ్ కాంట్రాక్ట్స్లోకి ఎంటర్ అయినప్పుడు ఇలాంటి ట్రాన్సాక్షన్స్ని మనం we cannot consider it as deposits. So ఒకసారి ఆన్సర్ we just verify the suggested answers what they were given. Presentation is important, so we just concentrate on keywords for presentation. Answers, MCQs answers just check once, verify చేసుకోండి. Unsecured deposits 36 months, 8 years, 18%, yeah, all correct. According to rule 2 subsection 1C, clause 8 of companies acceptance of deposits rules 2014, The following amounts, if are received by a company in the course or furtherance of purpose, in the furtherance of business, or in the course of or for the purpose of the business of the company, shall not be considered as deposits. That is the first point. Any amount received as an advance for the supply of goods or provision of services accounted for in the manner whatsoever to be appropriated within a period of 365 days from the date of acceptance of such advance. Any advance is received in the course or furtherance of business. However, in case any advance is subject matter of any legal proceedings before any court of law, the time limit of 365 days shall not apply. ఏదైనా లీగల్ ప్రొసీడింగ్స్లో పెండింగ్లో ఉంటే ఇట్ కుడ్ నాట్ బి కన్సిడర్డ్ యాజ్ 365 days. నెక్స్ట్, any amount received as an advance in connection with consideration for an immovable property under an agreement or arrangement. However, such advance is received required to be adjusted against such property in accordance with terms of agreement or arrangement. Any amount received as security deposit for the performance of the contract for supply of goods or provision of services. Next, any amount received as an advance under long-term projects for supply of capital goods except agreements are entered into for purchase of immovable properties. Any amount received as an advance towards consideration for providing future services in the form of warranty or maintenance or contract as per the agreement, as per the written agreement or arrangement. Warranty or maintenance. If the period for providing such service does not exceed the period relevant as per the common business practices, or 5 years from the date of acceptance of such service, which is less. Any amount received as an advance and as allowed by any sectoral regulator or in accordance with the directions of central or state government. Any amount received as an advance for subscription towards publications, whether in print or electronic media, to adjust against receipt of such publications. However, if the amount received under A, B and D above becomes refundable due to the reasons that the company accepting the money does not have necessary permission or approval whenever required to deal with the goods or properties of services for which the money is taken, then the amount received shall be deemed to be deposit under these rules. Further, for the purpose of this subclause, the amount shall be deemed to be deposits on the expiry of 15 days from the date becomes due for the refund. For the purpose of this subclause, that deposits amount, such amount has to be deemed to be deposits on the expiry of 15 days, like securities ఇష్యూ చేసినప్పుడు సబ్స్క్రిప్షన్ ఫుల్ఫిల్ కాకపోతే 60 days లోపు, రైట్, ఆ 60 days అయిపోయిన తర్వాత వితిన్ 15 days లోపు ఉన్న అమౌంట్ మొత్తం రిటర్న్ చేయకపోతే దాన్ని డిపాజిట్స్గా కన్సిడర్ చేయాలని చెప్పి ఇక్కడ సబ్స్క్రిప్షన్ ఆఫ్ షేర్స్లో ఒకసారి చూసాం మనం, రైట్. ద సేమ్ థింగ్ హియర్ ఆల్సో దే వర్ స్పెసిఫైడ్ వితిన్ 15 days లోపు such amount has to be refunded, otherwise it could be considered as deposits. Acceptance of deposits by a company from its members. The second question, just we have to refer. Second question, state the procedures to be followed by a companies for acceptance of deposit from its members. మెంబర్స్ దగ్గర నుంచి డిపాజిట్స్ యాక్సెస్ చేసేటప్పుడు ప్రొసీజర్ ఏంటి అని అడుగుతున్నారు. అండ్ వాట్ ఆర్ ద ఎగ్జంప్షన్స్ అవైలబుల్ ఫర్ ప్రైవేట్ లిమిటెడ్ కంపెనీస్కి. సెకండ్ ఆన్సర్, సజెస్టెడ్ ఆన్సర్స్ వచ్చేసి Second suggested answer, acceptance of deposits by company from its members. As per section 73 subsection 2 of Companies Act 2013, a company may subject to the passing of resolution. First, it has to pass a resolution in general meeting and subject to such rules as may be prescribed in the consultation with the Reserve Bank of India, accepts such deposits from its members on such terms and conditions, including the provisions of security, that is creation of charge, if any, or for the repayment of such deposits with interest as may be agreed upon between the company and its members, subject to the fulfillment of the following conditions, namely issuance of circular to its members, including therein a statement showing the financial position of a company. The credit rating agency has to obtain the credit rating has to obtain from the credit rating agencies the total number of depositors and the amount due towards deposits in respect of any previous deposits accepted by the company or any such particular such form as may be such manner as may be prescribed. Filing a copy of circular along with a statement with the register of companies within a 30 days from the date of issue of circular, depositing on or before the 30th day of April each year such sum which shall not be less than 20% of the amount of such deposits has to be transferred to the deposit repayment reserve account, right? It has to be kept in a separate bank account, and after that certifying that the company has not committed any default in the repayment of deposits, accepting that either before or after commencement of this act or payment of interest on such deposits where the default had occurred, the company made good the default and the period of 5 years had lapsed since the date of making a good of default, and providing a security, that is creation of charge if any for the due repayment of the amount of deposits or the interest thereon, including the creation of such charge on the property assets of the company. Every deposit accepted by a company shall be repaid with the interest in accordance with the terms and conditions of the agreement. Where a company fails to repay the deposit or part thereof or any interest thereof, the depositor concerned may apply to the National Company Law Tribunal for an order directing the company to pay the sum due or any loss or damage incurred by him as a result of such non-payment, or and for the other orders NCLT may deem fit. So what are the exemptions to certain private companies in terms of notification GSR 464 dated 5th June 2015 as amended from time to time, clause A to C and E of subsection 2 of section 73 with respect to issue of circular, filing the copy of such circular with the registrar, depositing of certain amount and certification as to no default committed shall not apply to the private company where which accepts from its members monies not exceeding 100% of aggregate of paid up share capital, free reserves and securities premium account, which is a startup for 5 years from the date of its incorporation, which fulfills all the following conditions, namely uh, which is not an associate or subsidiary company of any other company, first point. Second, if the borrowings of such company from a bank, financial institutions or any body corporate is less than twice of its paid up share capital or 50 crores rupees, whichever is lower. Third point, such a company has not defaulted in repayment of such borrowings subsisting at the time of accepting deposits under this section. However, such a company as referred to in clause A, B, C shall file the details of monies accepted to the registrar in a specified manner. The form DPT 3. Such certification also filed in the DPT 3. Appointment of trustee for depositors. It is a third question, just for third question. Third question is explain the provisions for the appointment of trustee for depositors under the Companies Act 2013, read with acceptance of deposits rules 2014. Third question and its answer. Appointment of trustee for depositors. In this respect, the following provisions are required to be observed as mentioned in Rule 7, Companies Acceptance of Deposits Rules 2014. One or more trustees for depositors need to be appointed by the company for creating security for the deposits, that is, to protect the interest of depositors. A written consent has to be obtained from the trustee before authorizing him or before appointment. A statement shall appear in the circular or advertisement with reasonable prominence to the effect that the trustees for the depositors have given their consent to the company for such appointment. The fourth, the company shall execute a deposit trust deed in Form DPT-2 at least 7 days before issuing the circular or circular in the form of advertisement. No person, including a company that is in the business of providing trusteeship services, shall be appointed as a trustee for the depositors if the proposed trustee is the director or key managerial person or any other person or an employee of a company or of its holding subsidiary or associate company or a depositor in the company, and the person is indebted, the trustee person is indebted to the company or its subsidiaries or its holding or associate company or subsidiary of such holding company, is not eligible to appoint as trustee. That whatever the person appointed as trustee has any material pecuniary relationship with the company, then he is not eligible. That whatever the person he has entered into any guarantee arrangement in respect of principal debt secured by your deposits or interest thereon, and is related to any person specified in clause A of above. No trustee for depositor shall be removed from office after the issuance of circular or advertisement and before the expiry of his term, except with the consent of all the directors present at a meeting of the board. In the case of companies required to have independent directors, at least one independent director shall be present in such meeting of the board. The next, that is the fourth question, is related to which topic? What are the provisions relating to credit rating which an eligible company must follow if it wants to raise public deposits? The provisions relating to obtaining of credit rating to be followed by an eligible company are contained in section 76 of Companies Act 2013 and Rule 3 subsection 8 of Companies Acceptance or Deposits Rule 2014 as amended from time to time. Accordingly, an eligible company which desires to raise public deposits shall be required to obtain a rating from a credit rating agency, including its net worth, liquidity, ability to pay its deposits, and due date from a recognized credit rating agencies. The given rating, which ensures adequate safety, shall be informed to the public at a time of invitation of deposits from public. Further, the rating shall be obtained every year during the tenure of deposit. As per 3 subsection 8 of companies, copy of credit rating which is being obtained at least once in a year shall be sent to registrar of companies along with the return of deposits in the form DPT-3. Further, the credit rating shall not be below the minimum investment grade rating or other specified credit rating for fixed deposits. It shall be obtained from any one of the approved credit rating agencies as specified for non-banking financial companies in the Non-Banking Financial Companies Acceptance of Public Deposits RBI Directions 1998 as amended from time to time. Samit, one of the director of Zara Technologies Private Limited, a startup company, requesting his close friend Ritesh to lend to the company 30 lakhs in a single tranche by way of convertible note repayable within a period of 6 years from the date of its issue. Advise whether it is deposit or not. So, in terms of Rule 2, Subsection 1C 17, if a startup company receives rupees 25 lakhs or more by way of convertible notes, convertible into equity shares, or repayable within a period not exceeding 10 years from the date of issue in a single tranche from a person, it shall not be treated as deposits. In the given case, Zara Technology Private Limited, a startup company, received 30 lakhs from Rajesh Ritesh in a single tranche by way of convertible note, which is repayable within a period of 6 years from the date of its issue. So, in the view of Rule 1C of 17, which requires convertible note to be repayable within a period of 10 years from the date of issue, then the amount of 30 lakhs shall not be considered as deposits, shall not be treated as deposits. It was more than 25 lakhs. Below 25 lakhs, it may be considered as deposits. 5B, second question. Polyester Traders Limited received a loan of 30 lakhs from Rachna, who is one of the directors. Advise whether it is a deposit or not. First, she's a director, so it is not deposit. Second, in terms of 21C8, any amount received from a person who is a director of a company at the time of giving a loan to the company shall be not be treated as deposit if such director furnishes to the company at the time of giving a money a written declaration to the effect that the amount is not being given out of funds of acquired by him by borrowing or accepting a loans or deposit from others. Or further, the company shall disclose the details of money to accepted and board's reports in the given case. It is assumed that Rachna was one of the director of Polyester Trader Limited when the company received a loan of 30 lakhs from her. Further, it is assumed that she had furnished to the company at the time of giving the money a written declaration to the effect that the amount was not being given out of funds acquired by her by borrowing or accepting loans deposit from others. And in addition, the company had disclosed the details of money so accepted in the appropriate board's report. So if these conditions are satisfied, then 30 lakhs shall not be treated as deposit. And third, City Bakers Limited failed to repay deposits of 50 crores and interest due thereon. Even after the extended time granted by the tribunal, is the company or Swati, its officer in default, liable for any penalty? Yes, both the persons will be eligible for payment of deposits because they were defaulted, right? Third, by not repaying deposits of 50 crores and its interest thereon, even after the extending of time by the time granted by the tribunal, City Breakers Limited has contravened the conditions prescribed under Section 73 of Companies Act 2013. Accordingly, following penalties is levied. Punishment for the company City Bakers Limited shall, in addition to the payment of the amount of deposit with the interest due thereon, be punishable with a fine which shall not less than be the rupees 1 crore or twice the amount of deposits accepted by the company, which is lower but which may extend to 10 crores. Punishment for the officer is in default. Swati being the officer is in default. shall be punishable with the imprisonment as well as imprisonment for 7 years as and with a fine shall not less than 25 lakhs and which may extend to 2 crores. However, further, if it is proved that Swati had converted, contravened such provisions knowingly, willfully, with the intention to deceive the company or its shareholders, depositors, or creditors, or tax authorities, she may will be for an action under Section 447, punishment for fraud also. Then 5.4. 5.4th question. 5D. Srinagar Ready-Made Garments Limited wants to accept deposits of 50 lakhs from its members for a tenure which is less than 6 months. Is it possible? Maximum no, but in some circumstances may accept. So just we verify the answer. Just we know. According to Rule 3, subsection 1, a company is not permitted to accept or renew deposits which is repayable on demand or in less than 6 months. Further, the maximum period of acceptance of deposits cannot exceed 36 months. However, as an exception to this rule, for the purpose of meeting any of its short-term requirements of the funds, a company is permitted to accept or renew deposits for the repayment of earlier than the 6 months, subject to the conditions that such deposits shall not exceed 10% of aggregate of a paid-up share capital, free reserve securities premium of the account of company, and such deposits are repayable only on or after 3 months from the date of such deposits or renewal. In the given case, Srinagar Ready-Made Garments Limited, it wants to accept the deposits of 50 lakhs from its members for a tenure which is less than the 6 months. It can do so if it justifies that the deposits are required to be for the purpose of meeting any of its short-term requirements of funds, but in no case such deposits shall exceed the 10% of the aggregate of paid up share capital, free reserve securities premium, an account, and further such deposits shall be repayable only on or after 3 months from the date of such deposits. And 5D, 5E, fifth question, it is 5E. Is it in order for the Diamond Housing Finance Limited to accept or renew deposits from public from time to time? Housing Finance Limited, finance company ki it is not the case. 5. According to Section 73 of Companies Act 2013, no company can accept or renew deposit from public unless it follows the manner providing under Chapter 5 of the Act. Contains provisions regarding the acceptance of deposits by the companies. For acceptance or renewal of deposit from public, however, provision of Section 73 subsection 1 states that nothing in the subsection shall apply to the banking company and non-banking financial companies as defined in the Reserve Bank of India Act 1934, and to such other company as the central government may, after consultation with the Reserve Bank of India, specify in this behalf. Further, rule number 13 states that the company's acceptance of deposits rules 2014 shall not apply to the housing finance company registered with the National Housing Establishment under the National Housing Bank Act 1987 in the given case. It is assumed that the Diamond Housing Finance Company Limited is registered with the National Housing Bank and thereof an acceptance of deposits rule shall not apply to it. Hence, the Diamond Housing Finance Limited, being an exempted company, can accept or renew deposits from the public from time to time without following the prescribed manner. The deposits provisions are not applicable for this. So the question number 6 is regarding, ABC Limited, having a net worth of 120 crores, wants to accept deposit from its members. The directors of a company having approached you to advise them as what special care has to be taken while accepting such deposits from the members in the case their company falls within the category of eligible company. According to Section 76(1) of Companies Act, eligible company means a public company having a net worth not less than 100 crores or a turnover not less than 500 crores rupees and which has obtained the prior consent of a company in general meeting by means of special resolution and also filed the said resolution with the register of companies before making an invitation to the public for acceptance of deposits. However, an eligible company which is accepting the deposits within the limits specified under section 180 subsection 1c may accept the deposits by means of an ordinary resolution. According to rule 4a, an eligible company shall accept or renew any deposits from its members if the amount of such deposits together with the amount of deposit outstanding as on the date of acceptance of renewal of such deposits for the members does not exceed 10% of aggregate of paid up share capital, free reserves and securities premium account of company. ABC Limited is having a net worth of 120 crores in the given case. Hence, it falls in the category of eligible company. Then, the ABC Limited has to ensure that the acceptance of deposit from its members, together with the amount of deposit outstanding as on the date of acceptance or renewal of such deposits from the members, in no case exceed 10% of aggregate of paid up share capital, free reserves, and securities premium account of an account of company. So this is the conditions which could be followed for this eligible companies. Then the seventh question is regarding here sub questions also there. Define the term deposit under the provisions of Companies Act 2013 and comment questioning quoting relevant provisions whether the following amounts received by a company will be considered as deposits or not. 5 lakhs raised by Rishi Confectionaries Limited through issue of non-convertible debentures not constituting a charge on the asset of the company and listed on the recognized stock exchange as per the applicable regulations made by the Securities and Exchange Board of India. So